Good morning. My name is Vikram Raghavan. I work at the World Bank, and I want to welcome all of you on behalf of the World Bank and the American Society of International Law, International Economic Law Interest Group. Today, we will discuss vaccine equity and international economic law with a terrific panel. As our guests will probably explain, during the past few weeks, the discussions about vaccine equity have really focused on these proposals to waive intellectual property protections in relation to COVID-19 vaccines. And we planned this for a while, but obviously the events of the last few days makes this event today very timely because the US announced that it would support a waiver of intellectual property protections. And of course, there are discussions at the EU about what to do. Now, for the World Bank, this event is an important one, but we will be in sort of listening mode. We are not, this is not a World Bank event to discuss the World Bank's position, partly because this is an area which, we are listening to closely to what the experts are saying and what obviously our shareholders are discussing. And so it is still though very relevant to us because we are working together with the international community and our partners in several countries to accelerate the rollout of COVID-19 vaccines. As I think President Malpass said last month, there's been a significant commitment of World Bank funds for vaccines, for supply of vaccines to countries that have sought that financing. As the president of the World Bank urged wealthy countries last week to quickly free up excess vaccines for developing economies that are now facing much greater needs, as we all know, given what we see in the headlines. So today, we have an excellent panel that will help us understand this debate and how it affects the rollout of vaccines. I think that's one of the key issues, right? So this is not just an academic debate. There's a very practical dimension to it, which I hope Ben will sort of tease out during the discussions. Without much ado, let me quickly introduce the guests. We have Kolofelo Kugler, who is a counsel at the Advisory Center on World Trade at the World Trade Organization. Sorry, it's the Advisory Center on WTO law. I should know this because I've been quite involved with that center for a while, but she joined the center in 2015 and previously worked as a research assistant to a professor at the Erlangen-Nuremberg University and was a junior associate at the WTI advisors in Geneva, where she provided policy advice on trade and services and technical assistance to developing countries on WTO matters. She's also cooperated with development agencies on research on regional integration and aid for trade. Our next speaker or our panelist, depending on how Ben wants to organize this, is Dalendiebo Shabalala, a associate professor of law at the University of Dayton School of Law. His primary teaching obligations are in contract, but also in intellectual property and business law. Professor Shabalala's research focuses on the interaction of intellectual property law, especially patent law, with the rights of indigenous peoples and climate change. He's a member of the Climate Action Network Technology Working Group and continues to provide advice on patent law and technology licensing to developing countries and civil society organizations in climate change negotiations. So we're great to have him. And then we have Professor Madhavi Sundar, a professor of law and associate dean at Georgetown University Law Center. She was named a Carnegie Scholar and has been a visiting professor at Yale Law School, Chicago Law School, and Cornell Law School. And her work traverses numerous fields from intellectual property to human rights law and the First Amendment. And then last but not the least, our moderator, who basically has been the instigator of this event and is also involved with the American Society of International Law's International Economic Group that's organizing today's event, Professor J. Benton Heath. World Bank colleagues will recall he spoke to us last year during the height of the crisis on the international trade dimensions of COVID-19. So we're happy to have him back. Professor Heath is Assistant Professor of Law at Temple University Law School. His primary research interests include international trade, investment law, dispute resolution, global health, administrative law, public international law and the national security dimensions of trade and investment. Professor Heath has previously practiced law at the US State Department and at the law firm of Curtis Millett, Prevost Court in Mosul. So it's a pleasure to have all of you here. And without further ado, I would hand it over to you, Ben, to basically get us rolling, but also to give us a few in-house rules in terms of how you want to conduct the event. And we look forward to hearing from you. Thanks again.
Thank you so much, Vikram, and thanks to the bank for co-organizing this with us. It's a real pleasure to be talking about this really important issue at this moment when things are developing really rapidly. I want to thank our panelists for joining us. There's a great deal of expertise in the room, and very little of it is mine. And so I'm here to learn quite a bit from the speakers as well. I'm gonna talk for a couple minutes just to set the stage. But right at the outset, what you're about to hear is going to be about 10 or 15 minutes from each of our panelists, followed by some time for Q&A. I think we have till 12:30. And for Q&A, you can use the Q&A function at the bottom of your screen. If you're on a PC, if you're on a device, I don't know how to help you. But the Q&A function at the bottom of your screen, or if you would like, you can send a chat to the panelists with your question in it. And if you do it that way, I will read it out at some part during the question and answer exchange, and I won't attach your name to it. So for example, if you don't want your name to be associated with your question for whatever reason, but would like to get it in the mix, you can send it that way and direct your message simply to the panelists through the chat function. So those are our Zoom rules for this event: Q&A or chat for questions after the presentations. So when we talk about vaccine equity, what are we talking about? I think that at this point, it's relatively common knowledge that we've seen a deeply inequitable distribution of vaccines across the globe. One statistic from this morning was that 44% of the world's doses have been obtained by either Europe or countries in Europe or North America. These are regions that represent, by my calculation, less than 20% of the world's population. And many developing countries have managed to vaccinate less than 1% of their populations. So those are the numbers we're working with in stark terms. The impetus for this event, there were essentially two major events that were going on as we were thinking about putting this event together. And one in my mind was the spike of COVID cases in India, which began around mid-April and continues to be a massive humanitarian crisis. This is not the only place in the world where there are concerns. Experts have noted concerning signs, of course, in Brazil, as well as in Nepal, Colombia, Botswana, Namibia, Malaysia, and potentially other nations as well. The possibility for new variants to emerge at any time continues to be a threat. The second major development, which is on our minds, is, of course, the issue of a waiver of intellectual property rights for vaccines. As many of you probably know by now, last week, the United States expressed support for a waiver of intellectual property specifically for COVID-19 vaccines. Now, this announcement by the United States is sort of in dialogue with a proposal that came in October 2020 of last year that was led by India and South Africa. Now, the India-South Africa waiver proposal is broader. It suggests waiving intellectual property rights for a much wider range of COVID-related technologies and patents. And so there's still a lot to be negotiated here. There's nothing finalized. The legal basis would be Article 9 of the WTO agreement, which allows waiving certain protections, including trade-related intellectual property rights protections. But it's still yet to be seen what the scope of any waiver would be, what the terms of that waiver would be, and so forth. And regardless, whatever happens at the WTO is going to have to be coupled with other measures and other steps taken by the international community in order for vaccines and other technologies to be more equitably distributed across the globe. So that's the jumping off point for our discussion today. We're going to talk about what needs to happen in the trade space, and we're going to talk about what needs to happen globally to address this massive inequity in the distribution of resources. So what are the next steps? What is this waiver proposal? How does it link up with other things that need to be done? And how, if at all, does the world trade and IP system need to adjust to combat the crisis? Those are our sort of big questions for today. So with that, I'm going to turn it over first to Kolafelo, and then to Dalindyebo and Madavi in that order. And without further ado, Kolafelo, the floor is yours. Thank you very much for being here.
Thank you. First of all, I'd like to express my thanks to the organizers for this kind invitation. And I'm really looking forward to exchanging views with you. As you have been told, my name is Kolafelo Kugler, and I work for the Advisory Center on WTO Law. And I'd like to emphasize from the outset that the views that I present today are entirely my own, not necessarily reflective of the organization at which I work. Now, I'm going to use my time, or my presentation time, to just kind of take us back to basics and really sort of lay the land in terms of what WTO law has available for members that may not have the capacity to produce their own vaccines in their country. I think this is an important conversation, although basic, so those who already know this can take this opportunity to go grab some coffee. But I think it's important that we know what is available, because then it leads us to the question of what is the necessity for this waiver, if at all. And so concretely, I will give you just a tiny little bit more background than what Ben has kindly given us, and then talk about the provisions of the TRIPS agreements and related instruments. And then lastly, if there is a bit of time left, I'll just go through the steps of waivers of the WTO, just to kind of give context as to, what is the value of the support that Ben has told us the US has given to negotiating at least the text of the vaccine part of the waiver. And really, what is the value of it going forward, if there's any value at all? And so these are my initial comments, and obviously I'll be happy to expand upon these later. So as Ben has said, this waiver that South Africa and India, and obviously that was supported by about 2/3, and I just read an argument saying 2/3 of WTO members, comes from a concern that there might be, barriers to countries that don't have sufficient or zero domestic manufacturing capability for, drugs, and not only just drugs, right? We're talking about, not only just vaccines, but we're also talking about diagnostic kits, medical masks, PPEs, and ventilators. So it's really sort of all the medical products related to treating COVID. And so, not only does the waiver concern patents, which is one part of it, but it also concerns a waiver of copyrights, industrial design rights, and trade secrets. And so, although the conversation has really been pushed by vaccine, the waiver is much broader than that. And so now I'll just set the scene as to what is available to members right now under WTO law. And so this essentially speaks to compulsory licenses, which we have to note, compulsory licenses are only available to patents. So as I said to you before, there's 3 other rights that would, essentially required to be waived by this request. But compulsory licensing, only applies to patents. And so patents normally under WTO law, members must grant patents for 20 years. But obviously there are limited exceptions, which compulsory licensing is one of those. And now when this falls under Article 31 of the TRIPS agreements, which interestingly opens as follows: where the laws of a member allows, that member can grant itself, obviously a third party, to use a compulsory license to access, the matter that is subject to that patent. And there's obviously conditions, and conditions state that these compulsory licenses may only be issued in situations of national emergency, other circumstances of extreme urgency. So obviously COVID-19 would qualify here. And in these circumstances, what these compulsory licenses allow is that a member can, ask a third party to produce a generic pharmaceutical product, which is for the necessary medication, and under certain conditions, including limits on scope, duration, and the purpose of that authorization. Now, when you look at this Article 31, it's a sort of a long list of sort of these requirements and conditions and whatnot. But one of those under F states that those compulsory licenses have to be granted, must be authorized predominantly for the supply of the domestic market, which is obviously a problem for those members that have zero or very little domestic pharmaceutical production. And it also requires, the payment of adequate remuneration, which could also be problematic for members that do not have enough money to do so, because once a member offers the right holder has the right to review that amount. So obviously this was a constraint that was, raised by the Africa Group back in 2001 already. And this was during the throes of the HIV/AIDS pandemic. If you all know, about 94% of African medical products are imported. So obviously Africa is a very affected region for the production of these products. They would have to import the majority of these products. And so the Africa Group wanted to make sure that there's no impediment to them requesting the importation, so issuing compulsory license to get the importation of these essential medicines. All of these interventions led to the 2001 DoHA Declaration and the TRIPS Agreement of Public Health, and consequently to implement paragraph 6 of the DoHA Declaration. In 2003, there was the decision on the implementation thereof, which basically waived those obligations under Article 31F and H. So basically the requirement that you have to produce for domestic use, or you have to produce or manufacture domestically, and also the payment of adequate remuneration. So all of these changes now have been incorporated into the TRIPS agreement as Article Biz, and also the annex of the TRIPS agreement. And this came into force in 2017. So this is the first and only amendment of any WTO agreement that has come into force thus far. And many members have obviously ratified and accepted this, with the exception of about 32 members, mostly African states and states from the Caribbean, Latin America, and the Pacific. Now, so this is just sort of generally. I would then like to go into sort of interesting things about these provisions. Article 31, which is also obviously the DoHA Declaration, because basically this was just an acceptance of, the DoHA Declaration and the implementation decision, is that it defines pharmaceutical products. And one part of it, at the end, it says that it's understood that the active ingredients for its manufacture and diagnostic kits needed for it would also be included. So what it basically says is that, in a nutshell, of course, in addition to the patented product, which is the pharmaceutical product, would also be required to be transferred with that is the active ingredients and the diagnostic kits. And so when looking at the South Africa-India proposal and sort of their broader product list, it might not be, as broad as we think, because it seems like it's something that's already, contemplated in the text itself. But this is also an issue of discussion, which I'm happy to discuss with you later. Now, obviously, one of the biggest, I would say, hindrances to members using this, I think we know, and I've sort of explained that members can issue compulsory licenses. Members can even issue compulsory licenses sort of to import the necessary medical or pharmaceutical products, because these amendments specifically relate to pharmaceutical products. But I would say the process to triggering this mechanism is quite complicated. It requires notifications by the importing member of various things. So the names of the quantities of the drugs needed. You have to establish that you don't have enough capacity in-house to manufacture it in-house. The compulsory license has to, set out the terms, the quantities, the exact products, everything. And obviously there has to be the same type of notification coming from the exporting member. And there's various other, sort of requirements that must be fulfilled, including the fact that members must ensure that there's no re-exportation, obviously. And interestingly, paragraph 6 of the annex recognizes the desirability of promoting technology transfer and capacity building in the pharmaceutical sector in order to help the members that have little or no manufacturing capacity in pharmaceutical sectors itself. And it further states that exporting members are encouraged to use the system in a way that would promote this objective, and special attention must be paid to least developed countries. So built within this mechanism is a recognition that there is, members that have insufficient or zero manufacturing capacities, and, members are encouraged to assist members to gain this capacity or the manufacturing capabilities. And this provision is very much in line with the objectives of the TRIPS agreement under Article 7, which basically states the same, but more generally, broadly, obviously not talking about pharma. It states that the protection and enforcement of IPRs should contribute to the promotion and technological innovation and the transfer and dissemination of technology to the mutual advantage of both the users and the right holders to ensure a balance of rights and obligations. And what's also interesting is that it notes that there should be in a manner that is conducive to social and economic welfare. So it seems like, sort of generally the TRIPS agreement recognizes these challenges that members face, especially in accessing technology and accessing pharmaceutical products. So this is basically what the provisions are. It seems like there's a lot of flexibility available to members. It seems that there's a recognition that some members need this assistance. Some members have to gain access to these medications or to these pharmaceutical products, but this hasn't been quite easy, especially under WTO law. And I would say that the system, the challenges are twofold. One, the system is burdensome and inefficient. And two, very few members have actually amended their laws, domestic laws, to enable them to operationalize the Paragraph 6 system. And in fact, in 2004, Doctors Without Borders actually tested this system to see how it could work in practice. So basically, they approached a Canadian firm called Epitex, that produces antiretrovirals, and they asked the Canadian government to get involved to help send these antiretrovirals to an LDC in Rwanda. What's interesting about LDCs is that actually LDCs don't even have the same obligations that other members do, because they, under Article 66 and the waiver under Article 66, do not have to protect pharmaceutical products until the 1st of January 2033. And this has been extended time and time again. So this, getting an LDC to do this whole process would have been easier, because Rwanda didn't even have to issue a compulsory license, because it did not at the time and does not protect patents anyway. So this should have been a very sort of straightforward system. So starting from 2004, Canada had to go through the whole process of amending its legislation and getting the authorizations ready. This happened until late 2005, 2006, the process began. And the first sort of shipment of the drugs only went out in September 2007, and the second in September 2009. So the whole process lasted about, 5 years, depending on where you come from. And according to reports, this left a bitter taste in Epitex's mouth. There was just too many complications. The second obstacle, as I mentioned, is that members have not amended their domestic laws to actually permit this type of system to work. And just, looking at the notifications on the WTO website, the last member to notify this was in 2019, or actually the 2018-2019 reporting year. This was Samoa. And it's indicated that only 22 countries have done so. So only 22 countries in total have got domestic legislation that is actually conducive to the system actually working. Interestingly and noticeably absent from that list are countries like Brazil, the United States, and South Africa. Now, just with the very few minutes that I have left, I just want to talk about this waiver process. So as we know, this is a waiver that's been requested by, South Africa, India, and its co-sponsors, of course. And just, discussing, the context of WTO, what are waivers, how do they work, how easy or difficult is it to get through? And what we know, as has been explained, so we're talking about Article 9 of the Marrakesh Agreement, of the WTO Agreement. And what happens usually is that waivers are tabled. So as we know, this has been tabled on the 2nd of October 2020 already. And they're given 90 days for consideration and negotiation within the TRIPS Council before the TRIPS Council would have to, report to the General Council. this is obviously, has passed. 90 days has passed now. It started in October. Now we're in May of 2021. It's been, over 6 months now. But I guess the sticking point here, and notwithstanding the US's support of this waiver, this process requires consensus. And so we've seen at least, the Germans come out in opposition. We've obviously right at the beginning, and the US is one of the countries that was opposed to this waiver. And so, you really question the value of the US's support. I mean, I don't know. Maybe I think the value would be that it's sort of a signaling, pressure on pharma to do the right thing. We saw that the stock prices of, some of these drug companies have kind of fell after that announcement. So maybe there was a bit of a shakeup that was needed. And it's just not easy to get waivers through at the WTO. I mean, even I think the simple ones like this, 2001, the DoHA Declaration, it took, almost 2-3 years from the beginning to the end to get the system going. And that was sort of a given. And this is not a given. This is quite a controversial waiver. And so, but interestingly, there is some limited precedent to voting in waivers in the WTO system. And I mean, I think since then, there isn't any appetite. And I don't think this would be one of these waivers that would be voted on. But interesting for you to know that in 1995, Ecuador's accession was voted upon. And also there were waivers for a few members from Article 2 of the GATT. During that time, they were still transposing their schedules onto the HS system, and some of them were renegotiating their schedules. So they were given some limited, waiver through voting. But as I said, I don't think it's quite likely that this would go this way. So this concludes my intervention for now, and I'd be happy to continue, in the next round.
Thank you so much, Kolofelo, and that's a really helpful setting of the stage. One thing for folks on the call who may not be familiar with WTO decision-making procedures that Kolofelo said right at the end is that there's a norm in the WTO that decisions are made by consensus, which means the disagreement of one member could block the decision. And there's only limited precedent for voting, right? So while, depending on where you work, the idea of taking decisions by a majority vote might not seem that controversial. In WTO land, this is sort of this is a Rubicon that would be crossed, and that would have systemic effects. And that's something we could talk about more in Q&A if we get there. So with that, Dalianiebo, please take it away. And Dalianiebo has a new piece in The Conversation this morning, which is an online publication, which I also recommend you read.
Thank you so much. It's such a pleasure to be here with both Kolofelo and Madhvi. It's, I feel privileged to be able to talk to all of you about this and to give my, shall we say, unconsidered opinion on on where I think things are. So I think the place I will start is I share Kolofelo's basic description of the problem, right? I do think that one of the core problems that we have is that there's not enough licensing. The voluntary licensing that we do have is limited by geographical restrictions. So even if you have biotech, Pfizer licensing with Fosun Pharma in China, that voluntary agreement is limited to production just for China. And that we can't address this issue if we don't address this issue of production for export, and not just for export under what we call contract manufacturing agreements, which is what the majority of agreements out there are, right? You have a servicer who manufactures for the originator company, for the originator company to meet its own contract obligations, which means that all those agreements are primarily focused on Moderna, Pfizer, AstraZeneca, et cetera, meeting their obligations to pre-existing contracts to developed countries. And so that's a really big problem, that geographical restriction. And so one of the concerns that arises is, how do we provide an incentive for these companies to allow production for export? And one of the things that Kolofelo pointed to, and sort of the reason the 31 bis system really exists, right, is that compulsory licensing works more in the breach than it does in actual implementation. The very existence of compulsory licensing and the threat of compulsory licensing work to provide companies an incentive to engage in voluntary activity rather than allowing compulsory license to be issued to somebody else without their consent. So that means that if this waiver is going to work in some way, this incentive structure needs to be there somehow, that they're going to need an incentive to engage in export. The other thing that Cloverfellow points out, which I think is crucial, is how do we deal with a trade secret and know-how issue, right? That is crucial because for especially the mRNA vaccines, so much of it, I think Madhavi has pointed out, was it last year in the paper that you and William Nicholson Price did, that so much of this is tacit knowledge that is inside the company, and the patent doesn't tell you anything about it. How are you going to get access to that? If the company isn't going to voluntarily share it, is there any way to compel it? Is there a viable way to compel it? Are there useful ways to compel it? And so my argument is, if we're going to have something that works, either voluntarily or involuntarily, it's going to need to address both the export for production for export and the trade secret issue. And so what I've recently written is that any version of this waiver, whatever we negotiate, has to have those two minimal elements. Without those two minimal elements, it, I think, will be fundamentally pointless, right? I think it won't achieve what it's doing. And so that's what concerns me about this idea of what would constitute a narrow waiver. So I've been arguing, I think I can talk and say something about what I think a narrow waiver would look like. So my starting point is Article 31 bis in the TRIPS agreement. I think there are several steps to take to address and base the agreement on the pre-existing framework that we have on compulsory licensing for export under 31 bis. So for the patent side, I've argued that there are several provisions of both Article 31 and Article 31 bis that you can suspend precisely for this. I don't want to go into all of them, right? I have a whole blog post that talks about them, but in particular, one I will point to is a compulsory license has to be issued on a per patent basis. That's not sustainable, right? It has to be at the level of the product, not the patent. Right? So that's one of the things that the waiver is going to have to address. It has to be at the level of the product, not at the level of the. The other thing is we're going to have to get rid of, suspend the ability to get injunctive relief. So one of the things that companies can do is you can issue the compulsory license you've been to get, and then the company can bring up a case and they can get injunctive relief. And 31 bis asks for this kind of process, this kind of injunctive relief where you can prevent the export and prevent it from going out. And we need to suspend that because a company should be able to claim damages. If it was exported wrongly, issued wrongly, they should be able to get damages, but it shouldn't be able to prevent the sort of process from going forward, right? And so that's one of the key things I think this will have to take care of if we're to move as quickly as we want. I've got a couple of ideas around the sort of the notification processes and the role of customs in that, right? I think the thorny issue is going to be valuation of the compensation. Compensation is going to be necessary, right? I think we see that under 31 bis, we see that under Article 31. How do you calculate compensation? And I think one of the key things is, if we're going to have a successful one here, it's one of the things that the companies are going to insist gets agreed to in the negotiations at the WTO, not left purely to the sort of regulatory mechanisms at the domestic level, right? So I think that is one of the things that the countries, developing countries, are going to have to give up on, that control over the compensatory level would have to be agreed to in this waiver discussion. And I don't necessarily think that's a bad idea, because then it will allow the developing countries to bargain with the developed countries for who will pay for these as well. And that might allow the sort of funding component for compensation to be negotiated at the WTO level rather than sort of at the level of each developing country. Now, so I think that's element one and some of the key elements there. The other elements are around trade secrets and know-how. So Article 39 of TRIPS requires countries to protect trade secrets. Article 39.2 in particular defines the nature of the production, nature of the protection. And that's the basis on which countries believe they have that obligation. Now, there's some dispute around exactly what the scope of that is. I argue that because it imports standards from the Paris Convention, Article 10, on what constitutes honest and fair commercial practices, right? That really means that trade secret protection is defined by sort of each country's version and idea of what constitutes unfair competition. But what we haven't seen is any real discussion about what the interaction would be between the protection provided in Article 39 and what Article 31 and 31 bis, that if you issue a compulsory license, can you also require the technology transfer necessary in order to make the compulsory license effective? What we've seen in Article 39 is that Article 39 doesn't quite address that. There's some stuff around submission of data to regulatory agencies for approval under 39.3, but that doesn't really address that. What we do have is state practice. In the US, yes, indeed, under antitrust, and as we've seen in other circumstances, the Defense Production Act does allow that if you require or have a compulsory license for something, you can require technology transfer and know-how in order to enable that to occur, right? Madhavi pointed out, and William Dixon Price pointed out in their paper. Amy Kopczynski just pointed that out in her blog post on the Law and Political Economy blog as well, right? That is possible. You see this also in a few other countries, that they've always understood that when they issue a compulsory license, they can require the technology transfer in order to make the compulsory license effective. And so my argument is that while we don't have clarity on that in Article 39, the waiver will need to provide this clarity to ensure that countries know that they can indeed require that sort of sharing of know-how and trade secrets in order to make a compulsory license effective. And I think the waiver will need to ensure that. I don't think TRIPS is an actual serious barrier to that because we have state practice that suggests it's not. Those, I think, are the two areas that are the minimal elements of what a narrow waiver would imply in order to be effective. The proposal is much broader, right? It is one that is not a compulsory licensing approach. It is an entirely sort of a waiver approach where we say there shall be no protection for these and no enforcement of these during this period of time, right? That's the effect of it. And my theory of the case is the level of transformation and legislation required in most countries in order to implement the waiver is going to be so large, and the step up is going to be so large in order to implement the waiver as it is broad, that it might actually be somewhat preferable for developing countries to build on the Article 31 bis proposed system that they already have implemented. As Kulafelo noted, not all of them have implemented the 31 bis system, so that might undercut my argument entirely. But for those that have, a waiver that builds on that and just allows them to say, implementing legislation, the waiver means let me suspend Article 31 bis 2A2, we suspend Article 31 bis to F this, right? Is going to be much more doable than a system where they are having to go through their entire system where they are going to essentially say there is no protection for this period of time. It's going to complicate their takings and regulatory takings and constitutional law, right? There's a whole host of things that implementing a waiver that broad would implicate, whereas I think a much narrower waiver that looks at pre-existing frameworks that they've already implemented, I think is much more likely to succeed and be implemented. That said, I do share Cooler Fellow's skepticism about the timeline, but my idea of the timeline is that it's not that we're looking to see where we're going to end up December 2021. What I'm concerned about is where we're going to end up December 2022. And I think that's what the waiver is aimed at. What are we going to do? Are we going to be in this same situation of limited voluntary licensing in 2022, waiting at the back of the line for Moderna and Pfizer and AstraZeneca, et cetera, to get to developing countries? Or are we going to find manufacturers who are willing to sell to developing countries at a lower price, right, that they can get access to sooner? That's really the primary goal. Moderna has said, we would love to have all these orders from developing countries. And developing countries have said, we tried to order from you, but you told us you couldn't get to us until at the earliest 2023 or late 2022. So we didn't put any orders. And there's a chicken and egg situation. Moderna says, we can't ramp up production until we have orders. People say, well, we can't order from you unless you can get it to us at the time that we need it. And so there needs to be some kind of regulatory intervention to address that, I think, market failure there. Thank you. I look forward to questions.
Thank you so much. And I think that really sets us up for Madhavi's presentation. And I know a lot of you in the audience are sort of wondering, how fast does this go? What comes next? Where are we going to go from here? One of the questions we already have in the queue, is how much of a problem is IP compared to all the other, all the barriers that exist to distributing necessary treatments and vaccines around the world? Is IP the problem? And if so, where is that block coming into the system? And I think as we go on, we're going to talk a lot about a lot of these questions. And so with that, I'm going to turn it over to Madhavi.
Okay, great. So thanks so much. I'm really honored by the invitation. It's great to be here. Thank you to the organizers. And I'm so excited to be on this panel with Colafelo and Dall'Anievo. So thanks for having me. I'm going to jump into it. It seems like we have a lot of pressing questions. I guess really just before I get there, though, let me just start with a reminder of the cost of delay here, and especially given the months of delay that Colafelo has just reminded us of in terms of where we are right now. I mean, it was just over 20 years ago that the WTO was struggling with the humanitarian crisis of AIDS, especially AIDS in Africa, and there were years of debates about the limits of patents and a reckoning with public health. But during those years of delay and debate, we lost 5 million lives to AIDS before the WTO issued its DoHA Declaration in 2001, declaring that intellectual property rules should not prevent members from taking measures to protect public health. We have been here before, and yet we've seen delays since October after India and South Africa introduced this waiver. It was delayed, punted to December, punted to March, and now we are at an important crossroads indeed, when at least the United States has changed its stand. But we're still a long way off, right? So we still need Europe to come along, even just on this waiver. And that means addressing these big questions that have been thrown at it and the challenges that have been thrown at the waiver. So I guess first, I want to say, even though negotiating the issues that Dall'Anievo is talking about that must get into not a narrow waiver, but a broader, effective waiver, negotiating all these issues, seeing if we can get that consensus with getting Europe on board can take weeks, if not months, right? But in the meantime, there is hope that in the shadow of this threat of this coming waiver, companies will begin to come to the table. And in fact, Moderna did this already last Monday. Moderna, which has not actually pledged to this point up until last week to produce vaccines dedicated to low and middle income countries, Moderna last Monday committed to producing some, about 36 million doses by the end of 2021, and another 400 some million doses in 2022. So 500 million doses, but by the end of 2022. So it's a commitment to produce these for low and middle income countries, but it's still a longer term commitment than I think what we might want and like. So I guess I want to jump in specifically to, that's kind of where we are. We're hoping to get some folks to come to the table, and then we need to address these big arguments against to bring our friends in Europe and elsewhere on board too. But I guess I also want to state up front, agreeing with Delanyebo that the vaccine race is a relay and the waiver is just the first leg. We're still a long ways to the finish line. Tech transfer, as he said, and as many of my colleagues in the IP Academy have been saying, is going to be the critical next leg to getting us there. To end this pandemic, the Biden administration and other leaders must push drug firms to share their science, their know-how, their tacit knowledge of how to make the vaccine, not just the recipe, but how to make it with the world. And yes, we all acknowledge that there are numerous impediments aside from that too, including limited supply of raw materials, limited manufacturing capacity, and challenges with distribution on the ground. But make no mistake, let me address the first question that came up. Patents play an absolutely critical role in the current global inequity in vaccine access. There's been a limited supply produced, and it's rich countries that have rushed to the front of the line to buy up that limited supply for their populations many times over. In fact, the inequity is so stark that this week in the US, children ages 12 and up will likely be authorized to be getting this vaccine, when in many other parts of the world, in particular low-income countries, frontline workers don't have access to the vaccine yet. And what is it that has brought us here? Well, I'm just going to jump to the punchline here, right? It's just patents are certainly incentives for innovation, but what do they incentivize? They incentivize companies to innovate drugs that serve those who can afford to pay. So that's why we have numerous drugs to treat erectile dysfunction and baldness, but not malaria and tuberculosis, which are, alas, diseases of the poor. And similarly, vaccine companies have authorized just enough production of doses to those parts of the world that can pay. Rich countries, as we've seen, are the beneficiaries of that, but we are seeing little incentive to prioritize doses for the poor. And in fact, Moderna, up until just last week, had only pledged to produce just 700 million to 1 billion vaccines in 2021, and had not pledged at all to contribute to the philanthropic effort COVAX, which seeks to procure and deliver doses for lower income countries. Of course, they reversed that finally last week, but again, their pledges for 500 million doses through the end of, most of which will come in 2022. So the bottom line is that market incentives alone aren't going to meet the vaccine needs of the global population, much of which cannot afford to pay. So it's maybe less of, of patents standing in the way, of just patents not able to get us over the finish line to end this pandemic. We need government solutions to achieve global vaccine equity. Vaccine equity is a moral imperative, but it's also necessary for national security and public health, as these deadly variants threaten to undermine even our own progress here in the US. As the World Health Organization has put it, no one's safe until we're all safe. And so I guess I want to talk a little bit more, building on Kolofelo and Delanyebo, in terms of what the waiver does get us, and then what we need to do, all that we need to do beyond the waiver. So first, it does just waiving patent rights, as Delanyebo says, and as Kolofelo has described, the WTO processes right now that we have in place to issue compulsory licenses are quite cumbersome. They're patent by patent. In many of these vaccines, there are numerous patents involved. And as Delanyebo says, we need to focus on products, not patents. But we also recognize, as Kolofelo has described, that the rules are very cumbersome for countries that don't have the technological capacity themselves, the manufacturing capacity themselves, and the rules requiring what export countries would have to do to export doses are quite time consuming. And so this would first of all just cut through the bureaucracy and quickly enable us to enable export countries in particular to produce vaccines for countries where they're not able to produce the vaccines themselves, but also to get through the numerous patents that might be involved. You know, another benefit is that this waiver will, of course, give manufacturers around the world confidence that they can invest in the great cost of retrofitting factories and taking efforts to scale up vaccine manufacture without fear of patent litigation. Finally, also waiving patents can spur vaccine technology, further technology. Notably, even Moderna's vaccine production was slowed and jeopardized by numerous patent lawsuits. Not having to fear litigation could help spur competitors to develop additional safe and effective vaccines, which may also be more suitable to the climates and technological limitations of low and income countries. So we may see important new innovations here without the fear of patent litigation. I want to address, you know, obviously the key arguments against the waiver. And first, what we've heard a lot is that, well, there's no point of waiving these patents because we don't have enough manufacturers around the world who have the capacity to make these vaccines, in particular the mRNA technology, as we've heard about from Delignebo, is so complicated. We hear that even respected generic drug companies can't make these vaccines. But that's, again, what leads us to the more important step here, which is tech transfer. I think the waiver did a really important job in terms of getting the world's attention. Finally, I think even just in March, people weren't paying attention to this really important issue, certainly not last October, but now we have the world's attention, and that has now got to be focused on the key of technology transfer. The broader version of the waiver, as Delignebo said, focusing on, and Colafello said, focusing on know-how and trade secret and tacit knowledge, it certainly gives us potential to exert some more leverage on companies to share. But we need companies around the world, such as BioVac in South Africa, Cipla in India, to learn how to retool their manufacturing capacity to make safe and effective vaccines. And we need these companies to work with the World Health Organization and other public health experts who are standing at the ready to facilitate this technology transfer with companies in Thailand, Bangladesh, India, South Africa, et cetera. So it's critically, this is the critically important next step. And even African public health leaders too say there are countries on the continent like Senegal, South Africa, Tunisia, Morocco, Egypt, with the platforms needed to produce vaccines, but they need support. And they're asking for partnership. They're asking for partnership to empower local producers and to build capacity around the globe. You know, very briefly, the other arguments now are these unlicensed manufacturing, that this could produce unsafe vaccines. And again, that's why the technology transfer is so critical, and they should be working together in partnership to ensure that we're producing safe and effective vaccines. But I also really fear and am discouraged by that kind of talk, given the great success of India as the pharmacy to the developing world and generic and other drug manufacturers throughout the developing world, but also, you know, in Israel and elsewhere that are standing at the ready and have not been utilized in scaling up our production of these vaccines. In a time when vaccine hesitancy is real, for the drug companies to raise this talismanic, you know, fear around safety when we ourselves struggle with safety in the United States too, in our own manufacturing. It's a real issue, but it's not limited to just low and middle income countries. And we need to be honest and empower these manufacturers around the globe instead. These are some of the arguments. Of course, the last big argument is about incentives, that we're going to that the waiving of patents will destroy future incentives for drug companies to produce this life-saving technology and vaccines in the future. And in the context of COVID-19 vaccines, I think this really needs to be called out. The production of these vaccines were absolutely a product of public and private partnership. In the case of the Moderna vaccine, as many of you are now familiar with, the US government invested, it basically financed 99.9% of this vaccine in terms of the research and development, as well as the contracts for procuring doses. The other 1 million came from Dolly Parton. So this is not a case of private companies putting out, laying out all the risk. And in addition, it was the research of scientists at the National Institutes of Health that also provided some of the critical basic research underlying Moderna's vaccine. In fact, the US government owns the patent. So we have a lot of leverage here. We have the patent, a patent that's critical to some of these vaccines. We have the investment of US taxpayer dollars. And I think that goes to the point that private incentives can't drive this alone. These were the product of government investment to promote our national security and global public health. Global public health in this case is critical to our national security. So we've been arguing that we need to use this leverage, and now, as well as I think bargaining through for a broader waiver to include focus on sharing of technology and know-how. I guess I wanted to just add the last couple of points, and these are just kind of bigger framing issues, right? And that's that, up until last week, the US government's approach, and in fact, the global approach led by the Gates Foundation in partnership with the WHO, was to focus on donations. How do we address the problem of low and middle income countries and access to vaccines? It's through donating our excess supplies, donating money. The US government did donate $4 billion to COVAX. But this approach is admittedly limited in terms of its scope, right? So even at its most ambitious, COVAX sought to, COVAX's goal was to provide about 20% of the vaccines that are needed for low and middle income countries. So getting the most at-risk populations, but nowhere near herd immunity or enough to end this pandemic. And donations of our excess supplies are ultimately just a drop in the bucket with respect to what we need. And so a better diplomatic approach is sharing our technology, empowering manufacturers around the globe to be able to make vaccines for themselves, to learn the know-how to make vaccines to treat their own populations as well as their neighbors. And I guess I'll just end by saying that this was the very purpose of TRIPS to begin with. And I think Colofello started with this technology transfer. I mean, in the mid-1990s, developing countries resisted bringing intellectual property into these trade fora for the first time, precisely because it would mean high drug prices and threaten access to essential medicines, life-saving medicines. The only thing that brought them ultimately to the table was the promise of technology transfer. And if that promise is now, if wealthy countries with the ability to pressure drug companies, if they turn their back on that promise now during a once-in-a-century pandemic, I think the entire international IP structure will be fully exposed. And this drug companies really now need to cooperate because they're morally and legally obligated to do so. And I hope to see the Biden administration and other global leaders leading this effort more. I guess I'll add one last thing, right, which is just about maybe in questions we could talk a little bit more about India's role in this, because much of the pressure emerged just in the last few weeks as India spiraled. Again, if we hadn't, we can debate whether or not the delays from October through these last 6 months could have prevented this humanitarian catastrophe. But it's not just the catastrophe, but also that India otherwise would have been that primary producer of vaccines for low and middle income countries. And that pipeline has now been threatened because they need to focus on their domestic population first. And so I wanted to end with that, because I think another really important angle here is how UN Secretary General Antonio Guterres, he recognized that India's vaccine production capacity is one of the best assets the world has today. This is important, not just that we need to preserve that, but we need to recognize why. And it was because of the way India framed its patent laws before TRIPS and after TRIPS that has enabled it to become this robust producer of cheap, safe, and accessible medicines. And so again, I really hope at the end of the day that we not only address this immediate concern, but we relook at how our patent laws have put us in this situation today, but how our patent laws can also perhaps be retooled to promote broader access and humanitarian concerns. I'll end with that. Thank you.
Wonderful. Thank you very much, Madhavi. And thank you to all of our panelists. There are a lot of threads to pull on here. There is, as we say, room in the queue for folks if they want to put questions in the Q&A or in the chat to the panelists. I'll start, and I'll sort of fold in a question from Faisal Chowdhury that's in the Q&A here, which, to summarize, I think is really about the legitimacy of the WTO and or the TRIPS, right? So, to what extent is the current lack of distribution of vaccines a threat to the legitimacy of the TRIPS agreement as a piece of the world trade architecture, or a threat to the legitimacy of the WTO system more generally? And again, this might go back to how much you think that IP is really a blockage to distributing vaccines. But I think that's a big question here is, how is the WTO as an organization going to emerge? If there is a failure, is it a failure of the WTO as an organization? Is it a failure of WTO law? Or is it a failure of individual member governments? And so what is the legitimacy problem we're facing here, if any, I think, on your view?
If I may, I would just like to make a few points. I mean, I'm probably not going to come to the final answer, but I just want to jump in. I think the way that at least the IP system has been framed pre-TRIPS, right, is that the IP is the domain of each individual country. And so obviously the TRIPS is a minimum sort of standards agreement that says, hey, let's just standardize that. But, of the main, a lot of these things are dealt with domestically, And I think there's two sides to that. Yes, there's a lot of emphasis on members and individual members, individual countries, on how they deal with intellectual property. That kind of gives the WTO, or at least the TRIPS agreement, a bit of an out, I think. And there's also been a conversation that this discussion does not belong at the WTO. So this is not a trade issue. It shouldn't be discussed as a trade issue. And I mean, personally, if not the WTO, then where, right? Okay, yes, we have the WHO, we have the UN, we have all of these other fora, but I think one thing that members know about the WTO is that it's a binding dispute settlement system. And so if there is going to be recourse, then it would have to go to the WTO. So whether or not the WTO wants to or feels that it is the correct forum or not, there are and there has to be conversations to be had there. And so that's just my input.
Great, yes. And Dalan Diebo, did you have something to add on?
So there's sort of I think Khalifah points to the right point. There's sort of a domestic legitimacy issue and an international legitimacy issue, right? So the domestic legitimate issue is around the basic, what is our patent bargain? If the companies are arguing that any imposition on their rights to market control is bad, period, right? Which they have been arguing, and then they're still making the argument in this situation. I think that is a real problem because compulsory licenses are part of the patent bargain. They built into the system. They're part of the choice and the bargain that they made to patent things. So when there's a need for static efficiency, when there's a need for distributional concerns, that is built into the cost. And the idea is they will still get their money. What they have to give up is market control, but they don't give up compensation, right? And I think that's a really, really key difference. And if even under these circumstances, they refuse to give up control, I think that's a challenge at the domestic level to legitimacy of the system. And I think you can see that happening here in the US, why there was all the pressure in the Biden administration, et cetera. At the international level, Colorfellow, you know, the sort of forum shopping around IP has been so extensive, such that, for example, yes, TRIPS set things up, but then we had bilateral investment agreements where technology transfer requirements were negated, local working requirements were negated, right? All these things that were sort of safety valves outside of TRIPS to deal with these issues were negated, made the effectiveness of the technology transfer part of the TRIPS bargain essentially fall down. So at least as far as that's concerned, in many places, that's been somewhat negated. But there's WIPO, which has been a very effective, right, sort of champion of intellectual property rights in developing countries. And so to the extent that the failure might be at the WTO, other venues, bilateral investment agreements, WIPO and others are going to maintain, I think, a strong interest in IP protection and in creating constituencies in other countries for this type of protection. And so, as one of the questions Dr. Fazil Chaudhry pointed out, the WTO is suffering a bigger crisis, and TRIPS will be part of that. And I think, yes. But on intellectual property and intellectual property maximalism at the international level, I think that's going to continue because there are other venues where that will happen regardless of what happens at the WTO.
Yeah, I mean, I think the question of legitimacy is absolutely the question. Thank you so much. And this idea, as I think, as both of our my co-panelists have just said, this idea of promoting law without limits, rights not tethered to the promotion of human progress and well-being, but rather as an end in themselves. And during you know, a once in a century pandemic, it's just really hard for those arguments, I think, ultimately to withstand. That's why everyone has now come around to the waiver. I mean, not everybody, but even Bill Gates and the Gates Foundation, and the Pope has advocated for the waiver. But you know, this week, an IP professor arguing on the other side, Richard Epstein, writes, even if we were to suppose that wider availability of vaccines and other medicines could somehow allow developing nations to end the pandemic, the aggressive proposal to remove patent protection would still do more harm than good. So even if we assume that this waiver ends the pandemic, the costs are still greater apparently, because the cost to, and again, it's a speculative harm as a cost to incentives that doesn't acknowledge what Dalian Nebo is talking about, where they're still going to get their compensation, and so the speculative harm is somehow outweighing, I think, the great benefit of ending the pandemic. I think it's when we get to arguments like that that we really have to question this misguided cost-benefit analysis, and also ask for more than speculative arguments, right? That on the other side. So I think that I'm quite surprised that we're at this place when legitimacy is so tenuous, but at the same time we are, and they're doubling down. So.
Thank you. So we have another question in the queue from Greg Schaefer, who asks, compared to a waiver, would it not be in the interest of companies to enter into contracts with manufacturers You pair that with a non-disclosure agreement, cost plus provisions for export to countries in need, such as low-income countries or low and middle-income countries. And if that would not be more in the interest of companies, should we consider the waiver negotiation part of a process to compel those more voluntary or bilateral acts? And of course, the countries are still going to profit from selling their vaccines in the United States, Japan, Europe, and so forth, right? So I think Greg's question is, should we view this as this sort of multi-level, multi-layered process? And I see heads nodding, but so I believe the answer is to some degree yes. But Colafel, I'll turn it back to you if you.
Okay, I mean, if I will, and I think I said this in my intervention before. First of all, I don't even know if this wave is going to go through. So, but the value of the US, getting behind it, I think has already proven a point. I think the pressure, this is part of it. I think it's just going to be part of the pressure to pharma to start negotiating what they're supposed to have been doing a long time ago. And so for me, this is really what it is. Ultimately, it's just one of those sort of, push. And if not, then we'll just pull the trigger, So I think this is exactly where it's going, really.
Yeah, so my thinking on this is that so for the economists in the room, right, I think this is a classic market failure. Think about it. The price signal from developing countries is insufficiently large to shift them from meeting the obligations to developed countries to saying, okay, no, we'll supply you instead of them, right? The price that developing countries are going to have to pay just to get their attention in the market is so large that it's just not there. And they can't provide the good in the way that the demand side needs it. The good needs to be in developing countries by the end of this year. They are not in a position, given their current production capacity, to meet that demand. So somebody else has to meet that demand, right? And so one of the problems here is the voluntary licensing that's occurred is largely happening under sort of CDMO agreements, right? Contract and development manufacturing agreements, which are to meet our needs, but not. Right? And so one of the questions is, okay, can you take those and say to your suppliers, okay, here, we'll make other agreements that allow for that geographical restriction. And yes, you company can produce for that market. You company can produce for that market and engage in those negotiations, et cetera. I am skeptical that they will do so voluntarily, right? That's what this is, as Colafel pointed out, is going to be good for. I still think that they're going to spend more capital and effort in trying to stop the waiver than in actually engaging in the voluntary licensing. They're just going to see that there's going to be more value in doing so. So one of the things I think I am looking for is, and what I've been encouraging countries to do is go ahead and issue a compulsory license. See what happens. See who comes after you, right? Because I think it is not a lawless, but it's a part of a bargaining thing, right? Yes, you have the bargaining at the WTO. But part of the bargaining is also saying, I will now also myself issue a compulsory license or will threaten to as part of this process. And my worry about the waiver, which I haven't been as loud about, is that what it does, it pushes back the time at which many developing countries will likely to begin trying to think about issuing compulsory licenses. And they're going to put their efforts into negotiations. And I think if developing countries were to take that step now to begin threatening, you'd have that double pressure to actually push more voluntary licensing. But without that, I think we're in a position where the rational behavior of the companies is going to be not to actually do what Greg is saying, right? I think the rational behavior, their behavior is going to be, we'll get more bang for our buck by just killing the waiver.
Which is, I think, why we need to go beyond that, reliance on the companies to do this, even in the face of this, looming threat, because we need global leadership and strategy in terms of how to address not just this pandemic, but future pandemics, and that has to include the importance of empowering global manufacturers in vaccine production, in these new technologies, and so it absolutely, you know, if we can get companies to do a little bit more with this kind of looming stick, that's great. But they haven't done it so far. It's still probably not going to be enough. And the broader governance approach to thinking about these public health challenges now, but in the future, and what kind of pooling, what kind of cooperation, what kind of limits are we going to need, I think is what we need to be focusing on as well.
So that leads into a question that I had from the presentations. And I wonder if many folks who work in international organizations or the financial institutions might be wondering this as well, which is that this process of technology transfer that's sort of envisioned as the phase 2 of whatever needs to be done seems like a process that cries out for governance at the international level to some degree. And we have an international institution. We actually have several that deal with IP rights, right? And the WTO in particular, you know, deals with disputes over IP rights. We have international institutions that deal with export controls like the WTO and with foreign direct investment like ICSID. Is there an international institution for like governing technology transfer, coordinating? You know, what is the organizational structure globally, and where should folks be looking for that expertise, for that guidance, for that governance? Don Diego.
So there is a specific one for COVID, right? There is the CTAP, the COVID Technology Access Platform under the WHO, which is set up precisely with this goal of sort of voluntary pledges to share technology. Zero. But it nevertheless exists. It's institutional. It's within a particular organization. And so if the companies insist on having, I think it would be right to do so, on having a centralized sharing platform with a centralized dispute mechanism that would allow them to feel secure about who they shared it with, that would impose obligations on whichever company that information was shared with, CTAP would be a great platform to put it in and to negotiate that, right? And WHO has experience with this, right? The Medicines Technology Access Pool has great history on this. So WHO, I think, is well suited because they've done these kinds of technology sharing and development processes before, and CTAP is just an addition on that, and it pulls on the expertise of these other organizations, Gavi, et cetera, to do that. The companies will be smart to insist on having that kind of centralized mechanism with a proper dispute settlement thing that impose obligations on the third-party firms to do so. I think otherwise they'd be left with sort of each individual country's system for providing that kind of protection, right? And to get some kind of international arbitration process that would cover what CTAP was doing and the sharing process there, I think they feel much more secure. So my hope is that that's going to be on the table, and that's going to be one of the things I'm going to be pushing for as these go forward.
Do we have other comments on that? I do see something in the chat that the WHO has recently started a hub separate from CTAP. So hopefully things are moving in the right direction there. But Kolafelo and Madawi, I don't know if you wanted to jump in on that question. So we're running out of time. I think, you know, we're 80 minutes past the hour. I think we've covered a lot of ground. And I'm conscious of everybody's desire to have lunch or maybe, you know, turn off their cameras for a minute. So, so with that, I think I will thank the panelists and the participants. I think this has been an excellent event. I learned a lot, and I'm still learning a lot about this. As was noted, I think the profile of this issue has only been heightened really in the past month or so. And so, so I really think a lot of people are turning their minds to this. And we need innovation now for COVID, and maybe we need innovation in the long term with respect to technology transfer and rebalancing the various imperatives of having a more equitable and just distribution of resources. So thank you very much to everyone. And And thank you, Vikram, for co-hosting with us. Thank you to Aisel and my co-chairs on the interest group. And thank you to our panelists. This has been fantastic. So thank you very much.
Thank you very much, Ben, and to the panelists as well, from our side as well. I think a lot of colleagues listened in and were, I think we gained a lot of insights. And I also want to thank Paige and Esperanza, my colleagues who helped put this together. And actually, I think it's Esperanza who identified our three great panelists with your help. So again, thanks to the two of them. And we had a very good, diverse, and comprehensive panel. So we're very grateful.